May it please the court. I'm Mark Stuffa, counsel for the appellants. I would request 4 minutes for a rebuttal.
4 minutes, you got it.
Thank you. Your Honor, this is a case that this court should reverse based on the plaintiff's failure to prove standing at the inception of the case. There was no evidence at trial at all reflecting that the plaintiff was in possession of the original endorsed note at the time that this suit was filed. There was no Bailey letter, no screenshot, no testimony from the bank's only witness, nothing at all, no evidence at all showing possession of the original endorsed note at the time of filing suit. There are lots of cases which require that.
But they did match up. The attachment to the complaint matched up with exactly what was put in evidence, right?
Well, the copy of the note that was attached to the complaint was not in evidence, and we are adjudicating the sufficiency of the evidence. The copy of the note attached to the complaint was not in evidence. There was a request for judicial notice of it, but a request for judicial notice does not make something evidence under the Florida Supreme Court's decision in Dufauer and this court's foreclosure decision in Tomlinson. Pleadings are also not evidence. So that's the first part of my argument, is that when you're weighing the sufficiency of the evidence, taking judicial notice of a complaint does not get you there. It does not constitute evidence as a matter of law. Now, I realize that the 4th DCA has ruled that the copy of the note attached to the complaint along with the original at trial is sufficient to prove standing at the inception of the case. That was in Ortiz. That was decided after this case was fully briefed. My opponent did a notice of supplemental authority. I submit that this court cannot and should not be following that decision.
But that time out, just so I remember correctly, I didn't bring Ortiz with me, but Ortiz cited a case by the name of Clay.
Right,
Ortiz. In existence at the time, and Clay seems to be on all fours with Ortiz.
Well, Clay was a summary judgment case as opposed to a foreclosure case, and Clay was a third-party purchaser as opposed to the borrower, and that decision didn't really recite many facts in terms of what the summary judgment evidence was, so I didn't view that as terribly persuasive to this decision in this case at all. Ortiz is clearly the case that is most closely analogous, but several reasons why I submit that this court...
But, I mean, Clay was binding on the trial court in this case, is what I'm saying. I don't think it was particularly argued in the trial court, but it would have been binding, assuming it's controlling.
I don't think so, Judge. I don't think so, given I understand why you ask that, but given the procedural posture of Clay and how different it was, I don't think that would have been binding, but even if it was, it's certainly not binding on this panel. The facts at bar are an issue of first impression before this court. Now, the first point that I want to make here in terms of why you shouldn't be following Ortiz is that rules of evidence are created by the legislature. The legislature has the authority to create substantive rules of evidence, and the Florida Supreme Court has the exclusive authority to create rules of evidence to the extent those are procedural. That is conveyed by Article 5, Section 2 of the Florida Constitution. Now, there is nothing that conveys upon a DCA the authority to create an evidentiary presumption or to create a presumption or to create a rule of evidence at all. The legislature creates substantive law, the legislature creates presumptions, and the Florida Supreme Court creates rules of practice and procedure in all courts. There is nothing, and I have done a lot of research on this issue in the last couple of weeks, that you will not find a case that authorizes a DCA to create a presumption. Now, what you do see in the law is there are countless examples of the legislature creating presumptions, and those are set forth in our statutes. And there are lots of cases in a variety of contexts that create presumptions because the legislature created them and put them in statutes. One very obvious example is Florida Statute 671.21. This is part of Florida's UCC, the Uniform Commercial Code, which applies here, and this says, whenever this code creates a presumption, the trier of fact must find the existence of the fact presumed unless contrary evidence is introduced. So this code creates a presumption. The legislature creates a presumption. With all due respect, a DCA does not have the authority to create a presumption or to create a rule of evidence where one does not exist in the statutes.
I mean, that's your interpretation of Ortiz. Ortiz doesn't say we're following a presumption. They're following proof.
Well, Judge, it's interesting you say that because the initial version of this Ortiz that came out did use the term presumption and did say they were applying a presumption. That decision, curiously, was withdrawn sua sponte on rehearing with the current version that exists that doesn't use the word presumption, but if you read the language that it uses, it says, if the original note is introduced at trial and a copy of that note is attached to the complaint, then that is evidence. That's what you have in our case. Okay, so our case is on point, factually. If that happens...
Ortiz wasn't your case.
No, Ortiz is not my case. No, I'm sorry, I didn't understand your question. Then that is evidence. They are treating that as a presumption. That is clearly a presumption, okay? They're not using the word presumption like they did in the original version of the decision, but it's clearly a presumption, and I think the best way to show that is why I filed the notice of supplemental authority, where I went to Earhart on evidence, and if you look at section 303 of Earhart on evidence, and he lists out numerous different presumptions that apply in the law. Things like a rear-end collision. When there's a rear-end collision, we presume that the rear-end driver is at fault unless there's evidence to the contrary. Or we presume that when there's proof that a letter is mailed, that it is received unless there's evidence to the contrary. That is exactly what Ortiz says, is that we presume that a bank in a foreclosure case had possession of the original note upon filing suit, so long as they had proof at trial and a copy of the note is attached to the complaint. It absolutely is a presumption, unequivocally. There's no...
So just so I understand, by making that argument, are you making any concession that the proof would otherwise be would otherwise be adequate in this case, based on Ortiz or based on Clay? In other words, do you need us to say those cases create a presumption without saying so in order to reverse this final judgment?
Well, clearly those cases create a presumption, and I do think if you follow Ortiz, then you're not going to reverse. Okay, I think that's clear. I think this is squarely an Ortiz fact pattern, and that's why I'm telling you...
But we have to qualify Ortiz to say, even though they took out the presumption language, that they still applied a presumption. That's what you're asking us to do.
Well, yes, but I don't think that's... I
don't mind using common sense, but I need to find out what you're asking.
I think that's very clear, Judge. Look at the language in Ortiz. It very clearly is employing presumption language. It's very clear because it's saying if you look at the definition of presumption in 671.21, that's exactly what they're doing. This is a vanishing presumption. Right before footnote 2 in the decision, they're saying that proof that the original note is at trial, coupled with a copy of the note attached to the complaint, proves possession of the original note. That is evidence of it. As if evidence, unless there was contrary evidence. That is a vanishing presumption, just like all those other examples in Earhart.
What was the contrary evidence, if any, in this case?
Well, there wasn't any, Judge, which is one of the the third point that I raised in the notice of supplemental authority, which is this is not something that should be applied against my clients ex post facto. You know, when you, as a matter of strategy, when you're preparing and adjudicating one of these cases, you know, and we see that the plaintiff has no evidence of standing at the inception of the case, we have no reason to submit evidence on that issue. It's the plaintiff's burden of proof. So when they don't prove the issue of standing with anything, no screenshot, no Bailey letter, when they can't do that, I don't have a reason or a need to introduce contrary evidence. That's their burden. So you shouldn't now, where there is no statute in place that we would have been on notice of, come in and say, well, we're going to apply this against you retroactively. We had no notice of the issue at all. And so that's why I cited a case
of... Well, you argued failure of proof. There was no motion for judgment of directed verdict, right? You argued failure of proof.
Well, we asked for an involuntary dismissal at the end of the case.
At the end?
Based on the insufficiency of the evidence.
And the judge denied it, saying the proof has been provided, and it's only a 51%, 50 plus, a slight tipping of the scales, a civil case, right?
Well,
and the judge found under the circumstances of the note equaling the other note and everything, you know, the launch, the endorsement, that's good enough for the trial judge.
Here's the way I think you should look at this, okay? There were two possibilities based on the evidence introduced. One was that the bank had possession of the original note when the suit was filed. Two, that it didn't. It's their obligation to prove that it did. What this judge did and what Ortiz did and what I submit you cannot do is concluded that because one fact existed, we are presuming that this other fact exists without any other evidence. without any other evidence. Now, Judge, I ask you to take a look at Earhart, which I cited in the Notice of Supplemental Authority, to understand not only am I very firm in submitting that only the legislature can do this and you can't, and my opponent won't have contrary authority on that, and I even encourage you to ask, there won't be any because it doesn't exist, but this is a situation where you shouldn't employ that presumption even if you could. What does Earhart say that the circumstances where the law says presumptions like this apply? When the presumed fact is so likely to have occurred that it is unnecessary to present evidence. And experience demonstrates certain facts are true if other facts are shown to exist. For instance, your letter mailed. Proof that the letter mailed will create a presumption that it was received. Why? Because we trust the Postal Service. Over many years of experience, the Postal Service gets the job done. So the law creates a presumption there, unless there's contrary evidence. A rear-end collision. Lots of experience tells us that the rear driver is the one who's at fault, unless there's evidence to the contrary. Now, Earhart also explains, it doesn't say more likely than not, it says certain facts are true. Experience demonstrates certain facts are true if other facts are shown to exist. Now, one of the circumstances, as Earhart indicates following the case law, that these apply is frequently these presumptions involve situations when it is difficult to prove an event occurred. For instance, the presumption applies where a letter is mailed. It's presumed received. Why does that apply? Because it is really hard for the sender of the letter to prove the receipt, right? How does the sender of the letter prove receipt? That's a difficult thing to do. So the law creates a presumption in order to make it easier, and because we know through experience that that's so likely to have taken place.
Mr. Stoker, when was the loan originated?
One second, Judge. (2002).
And the default occurred when?
2010.
Didn't the witness testify that it essentially had the loan from a time very shortly after origination? And that it included, I thought, the way I interpreted it was the loan documents.
No, I don't read it that way at all, Judge. I cited, and in fact, I quoted out the transcript on.
Quoted out the cross-examination.
Sure.
But in his direct examination, he says, my interpretation is that Countrywide's previous entity of Bank of America, National Association, we would have held this entire life history of the loan. And then he talks further on about the loan documents would have been, the assignments would have done, and everything would have been done, and the transfer made soon after origination. Getting away for the moment about presumptions, even if that is not clear testimony, doesn't that raise a proper inference that the trial court apparently made that they've held it since sometime, not defined exactly when, but sometime well before a suit was filed?
Judge, I respectfully but strongly disagree with that. I didn't read anything in that testimony at all to support that sort of an inference, or whatever term you'd like to use in that regard. There was nothing that showed proof of possession of the original endorsed note. The witness didn't testify to that. There was no documents that showed that. The 50CA in Gonzalez ruled that you have to have documentary evidence.
Well, that's a lost note case. That's a lost note case.
Well,
They didn't have the note at the time they filed the complaint. Then they go to trial. They produce the note. Well, that doesn't show they had the note when they filed the case, because they said it's a lost note case. We have a one-count complaint here. There's no count for lost note. And you cite all these lost note cases.
The point, Judge, is that, well, I don't think I cited a lot of lost note cases.
Well, you cited 4. That's maybe not a lot, but it seemed
Judge,
like a lot to me.
I cite May and St. Clair, 2 decisions from this court, which are not lost note cases, which clearly require possession of the original note at the time that the suit was filed. I don't think there's any testimony that's competent substantial evidence that shows that at all. That's why I'm talking about this presumption issue. I don't see any way to rule in their favor unless you employ this presumption. I don't see that at all. I don't think it's even close. And I think that's why they argued in their answer brief the way that they did. That's basically all that they really said of substance in the answer brief is to try to say, well, there was a copy of the note attached to the complaint. So I want to get back to that presumption issue. The legislature has to do it. This court can't. I think that's why, I think, quite frankly,
You're
that,
almost at your 4-minute mark, you had about a minute to go. I didn't want to cut you off, but just to let you know.
so you've got the Florida Supreme Court in Shelton says the legislature creates presumptions. The Florida Evidence Code says the legislature creates presumptions, not the courts. It's just not the court's prerogative. And think about the circumstances where these are.
I know you want to talk about presumption, but on page 26 of the transcript, the witness testifies, he's asked, is it the normal practice of the Bank of America to maintain records as to when original documents are required? Yes. What the procedure is that upon origination and notice signed, and then it's sent to us, we image that note into our system, and we create a record of the time and date that image was created. Why is that, when you tie it into what he said earlier, that they essentially took the loan and documents shortly after origination? Why is that not enough?
Well, one, because it says imaged into the system. That doesn't say the original or a copy, and it says nothing about the endorsements or when they were done. It says nothing at all. That may be talking about a servicing theory. It doesn't say anything about possession of an original endorsed note. Nothing at all.
And then I have one other question. You said at the beginning of your argument that taking judicial notice is not evidence. Were you saying that taking judicial notice of the complaint and attachment does not prove the issue? Because I'm sure you're not saying that judicial notice does not constitute evidence.
No, that's what I'm saying, Judge, the
Okay.
taking judicial notice. And if you look at this court's decision in Tomlinson, which follows the Florida Supreme Court in Dufauer, it's very clear in that regard that taking judicial notice of the document is not a substitute for evidence and doesn't prove the issue substantively.
Taking judicial notice of a fact or a document as reflecting a fact is evidence. But I think what you're saying is the fact that there was a copy of a note attached to the complaint does not prove the fact of possession.
Absolutely,
Okay. I just wanted to make sure I understood what you were saying. Thank you.
And I want to make sure that the court sees this the way I do on not only that you can't do the presumption, but that you shouldn't. Presumptions like this apply when it's really hard for one party to prove the other issue, like the mailing issue. Think about
You're
that.
at 3 minutes. If you want to keep
Thank
going,
you. I want to
that's
make this
fine.
point. Thank you. I want to make this point. You send a letter, it's hard to prove that the other guy received it, right? Here, the knowledge of possession of the original note is within the bank's knowledge and purview, not ours. So why are we going to give them the benefit of a presumption when we're the ones who it's so difficult for us to prove? It's exactly the opposite of the mailing issue situation. So there's no reason to employ the presumption. If you follow Earhart in the line of cases that are all cited there, no reason to employ the presumption. The circumstances are exactly the opposite as that. So with that, I'll say the rest for rebuttal.
All
Thank
right,
you.
I'll give you 2.5. Napoli?
Good afternoon, Your Honors. May it please the Court, my name is Matthew Sissio, and I represent the plaintiff in the appellee, Bank of America.
I'm going to ask you to give me the spelling of your name. Matthew, I got.
Yes, last name Sissio, that's C-I-C-C-I-O, Your Honor.
You're with Shapiro?
I am with Aldrich Pite. We substituted in as counsel about a
Oh, you
week and a
subbed in?
half ago,
Okay, so
just recently.
they just didn't connect you on the facing sheet. Okay, proceed.
Correct. First and foremost, the defendant only raised one issue that was discussed in the briefing stage, and that is the substantive issue of whether or not Bank of America established standing at the commencement of the complaint. There's also a procedural issue that should be addressed here, and that's whether the standing argument was even preserved at the trial court. The defendant at the trial...
You recognize that we have held and other courts have held sufficiency of the evidence can be raised for the first time on appeal.
Yes, I have, Your Honor, and under 1.530E, I do agree that he can potentially raise this argument here, but the issue would be if, for whatever reason, this court does not find standing in our favor, if they never moved for an involuntary dismissal at the time of trial, and this is a case from this court, it's Colston v. State Farm 2D15-572, and this is a quote, "It is only by virtue of a motion to dismiss or motion for directed verdict that this court could direct dismissal on remand."
And that case did not address the rule, correct?
It did not address specifically
So
1.530E.
I can read the rule as you can. The rule seems to very clearly indicate it can be raised and preservation is not going to be a concern. The cases that I have read and am familiar with never seem to address the rule and its applicability or not, correct?
I agree, Your Honor. All the foreclosure cases that have dealt with 1.530E do allow for post-trial
So
motion.
my colleagues may want to ask you some questions about it, but I'd really like to get to the meat of the issue as to how did your client prove standing?
In multiple ways. The first being the most recent decision from the Ortiz case, as opposing counsel mentioned. I understand his presumption argument. However, I still think the court should follow that proposition as stated in Ortiz, as it makes sense. It's not good practice for the banks to be filing the original notes along with the original copy of the complaint. In fact, some counties don't even allow that. So the copy of the note.
You agree that the witness was never asked, on what date did you come into possession or the right to possess the note?
Well, that would be the second portion of where we did prove our standing at the commencement of the action. On 3 occasions, he stated that they received physical possession of the note, as you indicated, Your Honor, on direct on page 22 of the transcript, and then on cross-examination on page 44. On 3 different occasions, he says, we received possession of the note shortly after the origination of this loan. This loan was originated...
Hang on a second, because I'm looking at page 22 of the record, so let's go through it carefully. Tell me where it says that I received or we received possession of the note.
I was using your page number. Do you mind if I grab a copy of the
Sure.
transcript so we can go through it?
As you're looking at it, it's right in the middle of the page where direct examination resumed. I think that's what you're referring to.
I believe it's actually page 23, and this is
Okay.
and where it was maintained again in the normal course of business records. It is correct. This is actually I apologize, Your Honor, this is
Well, page 23 of the transcript at the top says, and these type of documents are created at the time of the transfer when they're notified. So clearly that's not referring to the note because that's newly created documents, right?
that would be documents created by other entities, but if we could just skip past that and point to page 44 of the transcript, Your Honor, on cross-examination, where Mr. Music, our witness, states, actually, we took possession of this. He's referencing the note.
Well, how do we know that's what he's referring to?
Because prior to that, they are discussing the endorsements being placed on the note. During this line of testimony, the defendant is inquiring about the endorsements on the note. Our witness doesn't necessarily answer specifically as to the endorsements, which would be proven through the Ortiz case.
It refers to the note.
Yes, he is certainly referring to the note here, and he says, we took possession of this from Mid-America Mortgage shortly from origination. As the opposing counsel mentioned, origination was 2002. Our foreclosure action wasn't until 2012. I think it's easy to infer that shortly after origination...
Was that a presumption if you're inferring?
Not for this year. I understand the presumption argument for something else. Maybe I misspoke as to inferring, but if our witness says that we received the original note shortly after origination was in 2002, and the foreclosure action is not until 2012, it must have been received prior to. Shortly after would not encompass a 10-year span, Your Honor.
Well, the question or the discussion I had with Mr. Stopa talked about some other testimony as well, but on page 44, line 14, we received this note in our offices shortly, it says from origination. Standard practice would be that the originating lender originates the note, then they give it to, I believe, the correspondent lender. Prior to do so, there's an endorsement. And then there's some questions about you don't know when the date of the endorsement. So I want to make sure I understand. Your position is we received this note in our offices shortly from origination leads to an inference that because origination was in 2002 and foreclosure or default wasn't until 2010, that shortly from origination must mean something less than 8 years or 7 years.
Yes, I believe that's substantial and competent evidence.
I just want to make sure that I had your entire position as to how this witness established standing.
Yes, as far as his testimony, that is how we establish it, but there's also, of course, the Ortiz case, which there's been no other case law to the contrary from any of the districts where you must provide a Bailey letter or...
Well, that wasn't decided until after this case. Can we legitimately apply Ortiz to this case by itself?
Well, even going back before that, you have, as you mentioned, the Clay County Trust case, which is what Ortiz followed, and it stands for the same proposition. That
Whether you went to trial or a summary judgment, you're saying for standing purposes, it wouldn't make a difference?
for purposes of standing, if you have a copy of the note attached to your original complaint,
That's what Ortiz says.
that's
I'm
what
just,
Ortiz
and that's
says.
what Clay seems to say, but it arose in a factually different context. It was a summary judgment case as opposed to a bench trial to conclusion.
It should apply to both, but even more so.
It's a legal concept, it's not a factual scenario.
Understood, but even more so, this case here is analogous to Ortiz, and it should apply to a trial, a summary judgment standard. I am not entirely sure, but certainly for the trial standard as it was in Ortiz. And there's other cases that have held that way also, dating back to Riggs versus Aurora. They don't say it as in-depth as Ortiz goes, but it does say that possession of the blank endorsed note is sufficient. And in those cases, there's no evidence from the bank aside from the copy of the original complaint bearing the same endorsement that's introduced at trial. There's no Bailey, or at least the opinions don't mention any Bailey letter, acquisition screenshot, or anything of that nature in those cases. And even in this case...
Mr. Stopa's argument, though, which there's some logic to it, is there might have been possession at one time, there could have been a photocopy made, possession could have been sent somewhere else, you still have the photocopy. You know, mere possession of a photocopy doesn't establish in and of itself standing at the time suit is filed, right?
I do agree with that, Your Honor, but the case
So
in...
attaching a photocopy of a note to the complaint does not in and of itself, as a fact, establish standing.
Yes, Your Honor, that in itself may not be sufficient. I understand
All right,
opposing
you're
counsel's argument.
qualifying may not. Why, when would it ever establish standing? If all you have is, Judge, we filed a complaint, there's a note there, the clerk has the original note now, it was filed last week, they look the same, therefore rule for us, we've got standing. I mean, how would that, without testimony that they had possession when they filed the note, when they filed the lawsuit, how would that be enough?
If that's all you have, it's definitely questionable, but we had more than that here in this case.
I understand, but you keep qualifying, and I'm not sure I agree with the qualification, absent additional information. And I hear what you're saying. In this case, we have additional information.
And yes, I mean, the fourth DCA case is great for us, and I'm not going to try to qualify it elsewhere, but here in this case, as I said, Your Honor, we have additional evidence aside from that, including the testimony from our witness, and above and beyond that, we have a loan payment history, and I know a loan payment history doesn't necessarily establish standing, but it's further evidence that we were the party entitled to enforce pursuant to 673-3011 at the time of filing the case. And I'd like to quote from a second DCA case in the Paguoro case, which Your Honors may be familiar with, which held, and I'll quote for the court, although the witness was unable to specify exactly when Countrywide first held the note, the payment history reveals that Countrywide began receiving payments from the appellants shortly after the closing date of the loan. That applies here. We accepted payments on behalf of the borrower to Bank of America pre-foreclosure. The case goes on to say, additionally, the loan payment history indicates that Countrywide paid taxes and other fees associated with the mortgage property prior to filing the complaint. This is a noteworthy factor in determining standing, as financial institutions are not known to incur expenses on behalf of properties for which they do not hold an interest. Again, and that applies here, the payment history which was admitted into evidence shows we received payments from the borrower prior to the foreclosure, and we additionally expended monies on the property, including taxes and insurance. Again, that is not dispositive, but all this evidence in its totality is sufficient to show that Bank of America had standing. Any
done.
further questions, Your Honor?
No, sir.
Okay, thank you.
Mr. Stope, I said you had 3.5 left, so
Thank you, Judge.
I'll give you starting now.
Your Honors, page 22 of the trial transcript, those questions were about the 559715 issue, a notice of change of servicer. That's all that was talked about there. There was nothing about possession of the original endorsed note. And then page 44, the testimony there was entirely about the sequence in which the two endorsements were placed on the note, whether one endorsement was before the other or vice versa. That had nothing to do with whether the plaintiff had possession of the original note before the suit was filed. So there was no testimony that showed that the plaintiff was in possession of the original note before the suit was filed. So the only way that you could have...
The words out of the witness's mouth, which may not help your position, those words are, "We received this note in our offices shortly from origination." Standard practice, and then he describes what we read earlier. Why, when you read the entire context of the transcript, why do we not take those words at face value?
Well, Judge, that's in response to a question about what business records have you been presented by your counsel showing the order in which the endorsements were put on
That may have
there.
been the question, but there's his answer. "We received this note in our offices shortly from origination."
I understand. A couple things. First, the shortly isn't defined at all. Second, there's nothing about the endorsements at all. Nothing about the endorsements at all. So nothing in the testimony that...
He may not have answered the question that was asked, but that's his testimony.
I understand. Nothing about the endorsements at all in that testimony, Judge. So there's nothing there that shows when the note was endorsed at all. And so you have all the cases that require they have to prove not only possession of the original note, but when it was endorsed. And that testimony doesn't say that it was the original. There's nothing there that says that it was the original note that they received in the offices, which is exactly the point. You have to prove possession of the original note. So they don't show that that was the original. Even if you take that one sentence as meaning something, it doesn't show it's the original, doesn't show that it was endorsed, which brings you back to the only way you could affirm is based on this presumption issue. And just as I told you, they don't have any authority for the proposition that you, a DCA, can create a presumption like this where it doesn't exist in the law, and you shouldn't here. Think about 702.015. The Florida legislature created a statute requiring certifications under penalty of perjury at the time a lawsuit is filed in a foreclosure case. Why? Because foreclosing lenders so frequently filed suit without possession of the original note. That's also why the Florida Supreme Court created 1.115, and years prior to that created 1.110B, because there was so much systemic fraud and misstatements by plaintiffs in their initial cases. So those are enormous, telling, glaring reasons why you shouldn't be employing any sort of presumption and just presuming away the entire case like the DCA did, like the fourth DCA did, even if you had the authority to do so, which you don't. I mean, this isn't like the U.S. Postal Service, the tried and true method, or a rear-end collision when you have... When you have the legislature have to come in and say, we're going to make you sign under penalty of perjury in every file, and the Florida Supreme Court, the first time in history, creates a rule saying you have to verify under oath when you're filing these because you keep not telling the truth with what you file, they have to prove the issue. This is within their purview. It's something that they should have done through something, a screenshot, a Bailey letter, something. They did nothing. You can't presume that away. The final judgment should be reversed. Thank you, Your Honor.
Thank you, gentlemen. Well done. We're going to move on to another case next on the docket. That would be the